Mr Speaker. My question is to the Minister of Labour. What situations would be defined as unreasonably withholding consent by an employer under her proposed changes to workers having access to their union in the workplace?
Mr Speaker,
the Honourable Dr Wayne Mapp.
On behalf of the Minister of Labour, the draft of the bill does not actually specify these situations. The reason is, of course, the Employment Relations Act 2000 provides guidance as to what actually is reasonable, as stipulated particularly in Section 21 of the Act, which deals with conditions relating to accesses to workplaces. There is, of course, also a body of case law around these issues which provides further guidance to parties about what might be considered as unreasonable access.
Carol Beaumont.
Supplementary. How much consideration did she take of her own department's advice that the current law is working before proposing to make changes?
The Honourable Dr Wayne Mapp.
Mr Speaker, 2 points here on behalf of the Minister. The first point is, in fact, the government is fulfilling a campaign commitment to New Zealanders, and it's worth reminding the member that asked this question that 45% of New Zealanders therefore voted for this policy. Secondly, on behalf of the Minister has had reports of union representatives stopping customers from actually coming onto the workplace, disrupting customers in the workplace, tying up workers for hours of productive time, and that led to the conclusion that it was absolutely imperative to fulfil our campaign commitments.
Carol
Supplementary.
Beaumont.
Thank you. Does she stand by her statement in regard to restricting the right of employees to invite union representatives into the workplace, quote, "The benefits, while symbolically significant, are likely to be marginal in practice," end quote? If so, why is she pushing this policy?
The Honourable Dr Wayne Mapp.
Mr Speaker, 2 reasons. One, we're actually, on behalf of the Minister, of course, fulfilling our commitments to New Zealanders who voted for us on this issue amongst other issues. And secondly, there is a number of occasions, there have in fact been 10 cases over the past 10 years that have gone to the Employment Relations Authority or the Employment Court, and indeed in one instance that proceeded to the Court of Appeal on precisely this issue.
Carol Beaumont.
Supplementary. How will her government's plans to restrict employees from organising in unions help reduce the wage gap with Australia by 2025?
The Honourable Dr Wayne Mapp.
Mr Speaker, on behalf of the Minister, of course, employees are not restricted from joining unions, and frankly this issue has got no relevance to closing the gap. In fact, it will make workplaces more productive and more efficient.
We come now to questions to members, and question 1 stands in the name of Darian Fenton.
Thank you, Mr Speaker. My question is